Welcome to Inside the Deal. I'm Kathleen Flynn, and I'm talking with Frank Bruno, who's an intellectual property attorney at Milbank Tweed. And we're talking about what startups in particular need to know about protecting their intellectual property. Frank, what's the most important thing for them to keep in mind?
I think the most important thing for startups to keep in mind, particularly technology startups, is that they need to have a plan for their IP, in particular their patents. They need to sit down and set aside some time and possibly some resources to meet with a patent attorney and develop a strategy going forward, to consider all their options.
Of course, that's a little self-serving since you are a patent attorney, but give us an idea of what happens if a tech startup doesn't do that. Like, what are some of the pitfalls?
Sure, and the pitfalls are that they go forward and lose rights that they could have had. They forego the ability to patent some key technology or protect their assets in a way that's going to be helpful to them going forward. They may also give up the right to maybe publish some of the information that might prevent their competitors from getting a patent and gaining a key competitive advantage.
One of the problems that I've heard when I talk to tech entrepreneurs like Alec Ixold at Adaptive Blue, he said that while he's waiting for a patent to come through, that somebody else comes along and can copy the idea, that it just takes a very long time. What kind of advice can you give entrepreneurs in that situation?
I would tell him, and I've read his blog, and I've read the entry you're talking about in particular, and he makes some good points and has some valid concerns. And in that case, I would say, again, talking to a patent attorney, you can learn about ways to expedite the process, to get your patent faster. One of the points he makes is that while you're waiting, someone can come along and copy your idea, and that's true, they can, but because you can't enforce a patent right that you don't have. You have to wait until you have the patent before you can enforce it. However, it's important to note that damages can begin running before the patent issues. So a copycat is a copycat at risk. Later on, when the patent issues, the patentee can go back and say, you're liable for damages dating back months or years before the patent actually issued. And that's sort of a nuance of patent law that an entrepreneur may not know. And it's all the more reason to sit down and have a conversation with a patent attorney.
So does that mean that the entrepreneur should be documenting things that they're seeing all along that they think may infringe on a patent should they in fact get the patent?
Absolutely. Diligence really there is key. It's about being involved and knowing your technology space, knowing what you're doing, and obviously what your competitors are doing as well. And doing your best to make sure that everyone's aware of what patents you've filed and what you're working on. That has an advantage.
Has it become harder to get patents?
Yes and no. I mean, as technology develops, people tend to rush in from area to area and try to patent whatever key technologies they can. There are changes in legislation, changes in court rules. Some people will argue both ways, really, that it could be easier, that it's more difficult. It's a balancing act, and it's ongoing.
And what about the effects of the economy? I mean, is it more important than ever to be trying to protect your intellectual property in economically challenging times?
I think it's always important to be diligent in protecting your IP, but what we find is that companies during tough times are going to leverage the patents that they have and look for potential licensees or litigation opportunities. So, to use an analogy, it's the squirrels who save their nuts for winter. They build up this IP chest as time goes on, and then when economic times become difficult, they look to those patents as a potential revenue stream.
One thing I think everybody is focusing on more now than ever is exits. And in fact, there's been such difficulty with exits and a bad quarter we've just finished in exits. But what should startups keep in mind about their patents when it comes to mergers and acquisitions?
Patents are an asset. They are an asset separate and apart from the inventions or the products that they cover. And so they can tend to be a key component of a merger or acquisition. They are an asset that shows up on the books. They can be licensed out, they can be bought and sold and used as security for a lien. So all things being equal, a company with patents is worth more than a company without them.
Okay, and we have time for one last question. So if you had any major tip that you would give the startup entrepreneur about patents, what would it be?
It would be to document everything you're working on, your technology. Keep good inventorship books. Keep an eye on what all your developers are doing day by day, so that when the time comes later on, if you choose to patent something, you have a good portfolio of information to choose from. And also, if your competitor comes up with a patent, you may be able to use your information to invalidate that patent.
All right, great. Thank you for the advice from all of us. Thank you to Frank Bruno, and thank you for watching Inside the Deal. I'm Kathleen Flynn.